parties before the United Nations General Assembly suggest the existence of a divergence of views concerning the events which allegedly took place in the Rakhine State in relation to the Rohingya. In addition, the court takes into account the Gambia's note verbal sent to Myanmar on 11 October 2019, in which the Gambia, referring to the reports of the fact-finding mission, wrote that, and I quote, that it understood Myanmar to be in ongoing breach of its obligations under the Genocide Convention and under customary international law, and insisted that Myanmar take all necessary actions to comply with these obligations, end of quotation. The court observes that this note verbal specifically referred to the reports of the fact-finding mission and indicated the Gambia's opposition to the views of Myanmar, in particular as regards the latter's denial of its responsibility under the Convention. In light of the gravity of the allegations made therein, the court considers that the lack of response may be another indication of the existence of a dispute between the parties. As to whether the acts complained of by the applicant are capable of falling within the provisions of the Genocide Convention, the court recalls that the Gambia contends that Myanmar's military and security forces and persons or entities acting on its instructions or under its direction and control have been responsible, inter alia, for killings, rape and other forms of sexual violence, torture, beatings, cruel treatment, and for the destruction or denial of access to food, shelter, and other essentials of life, all with the intent to destroy the Rohingya group in whole or in part. In the Gambia's view, these acts are all attributable to Myanmar, which it considers to be responsible for committing genocide. The Gambia contends that Myanmar has also violated other obligations under the Genocide Convention. The court notes that Myanmar, for its part, denied that it has committed any of the violations of the Genocide Convention alleged by the Gambia, arguing in particular the absence of any genocidal intent. For the purposes of the present proceedings, the court is not required to ascertain whether any violations of Myanmar's obligations under the Genocide Convention have occurred. Such a finding, which notably depends on the assessment of the existence of an intent to destroy, in whole or in part, the group of the Rohingya as such, could be made by the court only at the stage of the examination of the merits of the present case. What the court is required to do at the stage of making an order on provisional measures is to establish whether the acts complained of by the Gambia are capable of falling within the provisions of the Genocide Convention. In the court's view, at least some of the acts alleged by the Gambia are capable of falling within the provisions of the Convention. The court finds, therefore, that the aforementioned elements are sufficient at the current stage to establish prima facie the existence of a dispute between the parties relating to the interpretation, application, or fulfillment of the Genocide Convention. The court now turns to Myanmar's submission according to which the Gambia cannot validly seize the court as a result of Myanmar's reservation to Article 8 of the Genocide Convention. In this connection, the court recalls that Article 8 of the Genocide Convention provides as follows: any contracting party may call upon the competent organs of the United Nations to take such action under the Charter of the United Nations as they consider appropriate for the prevention and suppression of acts of genocide or any other acts enumerated in Article 3. The court considers that although the terms competent organs of the United Nations under Article 8 are broad and may be interpreted as encompassing the court within their scope of application, other terms used in Article 8 suggest a different interpretation. In particular, the court noticed that this provision only addresses in general terms the possibility for any contracting party to call upon the competent organs of the United Nations to take action which is appropriate for the prevention and suppression of acts of genocide. It does not refer to the submission of disputes between contracting parties to the Genocide Convention to the court for adjudication. This is a matter specifically addressed in Article 9 of the Convention, to which Myanmar has not entered any reservation. Article 8 and Article 9 of the Convention can therefore be said to have distinct areas of application. It is only Article 9 of the Convention which is relevant to the saisine of the court in the present case. Myanmar's reservation to Article 8 of the Genocide Convention thus does not appear to deprive the Gambia of the possibility to seize the court of a dispute with Myanmar under Article 9 of the Convention. In light of the foregoing, the court concludes that prima facie it has jurisdiction pursuant to Article 9 of the Genocide Convention to deal with the case. Given this conclusion, the court considers that it cannot accede to Myanmar's request that the case be removed from the general list for manifest lack of jurisdiction. The court now turns to the question of the standing of the Gambia, which was raised by Myanmar during the hearings. In this connection, it is recalled that in the advisory opinion of the court on reservations to the Convention on the Prevention and Punishment of the Crime of Genocide, the court observed that in such a convention, the contracting states did not have any interests of their own. They merely had one and all a common interest, namely the accomplishment of those high purposes which are the raison d'etre of the Convention. The court observes that in view of their shared values, all the states parties to the Genocide Convention have a common interest to ensure that acts of genocide are prevented and that if they occur, their authors do not enjoy impunity. That common interest implies that the obligations in question are owed by any state party to all the other state parties to the Convention. In its judgment in the case concerning questions relating to the obligation to prosecute or extradite Belgium versus Senegal, the court observed that the relevant provisions in the Convention Against Torture were similar to those in the Genocide Convention. The court held that these provisions generated obligations which may be defined as obligations erga omnes partes, in the sense that each state party has an interest in compliance with them in any given case. It follows that any state party to the Genocide Convention, and not only a specially affected state, may invoke the responsibility of another state party with a view to ascertaining the alleged failure to comply with its obligations erga omnes partes and to bring that failure to an end. The court concludes that the Gambia has prima facie standing to submit to it the dispute with Myanmar on the basis of alleged violations of obligations under the Genocide Convention. A second condition for the indication of provisional measures by the court concerns the rights whose protection is sought and the link between such rights and the measures requested. The court recalls that the power it holds to indicate provisional measures under Article 41 of the statute has as its object the preservation of the respective rights claimed by the parties in a case, pending its decision on the merits thereof. It follows that the court must be concerned to preserve by such measures the rights which may subsequently be adjudged by it to belong to the party. Therefore, the court may exercise this power only if it is satisfied that the rights asserted by the party requesting such measures are at least plausible. At the current stage of the proceedings, however, the court is not called upon to determine definitively whether the rights which the Gambia wishes to see protected exist. It need only decide whether the rights claimed by the Gambia on the merits and for which it is seeking protection are plausible. Moreover, a link must exist between the rights whose protection is sought and the provisional measures being requested. The court observed that in accordance with Article 1 of the Convention on Genocide, all states parties thereto have undertaken to prevent and to punish the crime of genocide. Article 2 of the Convention provides that, and I quote, genocide means any of the following acts committed with intent to destroy in whole or in part a national, ethnical, racial, or religious group what it characterizes as clearance operations carried out in Rakhine. Proportionate force was used by members of the defense services in some cases, in disregard of international humanitarian law, or that they did not distinguish clearly enough between Arakan Rohingya Salvation Army fighters and civilians, and that there may also have been failures to prevent civilians from looting or destroying property after fighting or in abandoned villages. The court also noticed that the United Nations General Assembly, in its resolution 73/264, adopted on 22 December 2018, condemned, and I quote, all violations and abuses of human rights in Myanmar as set out in the report of the fact-finding states in its report of 12 September 2018 that it had, and I quote, reasonable grounds to conclude that serious crimes under international law had been committed that warranted criminal investigation and prosecution, including the crime of genocide against the Rohingya in Myanmar. The fact-finding mission concluded, and I quote, on reasonable grounds, the factors allowing the inference of genocidal intent were present. The fact-finding mission reiterated its conclusions based on further investigations in its report of 8 August 2019. The court noticed that the fact-finding mission, in its 2018 detailed findings, also asserted, based on its overall assessment of the situation in Myanmar since 2011, and particularly in Rakhine State, that the extreme levels of violence perpetrated against the Rohingya in 2016 and 2017 resulted from, and I quote, the systemic oppression and persecution of the Rohingya, end of quote. In view of the function of provisional measures, which is to protect the respective rights of either party, pending the final decision of the court does not consider that the exceptional gravity of the allegations is a decisive factor, warring, as warranting, as argued by Myanmar, the determination to have Myanmar comply with its obligations under the Convention to prevent and punish acts identified and prohibited under Articles 2 and 3, including by ensuring the preservation of evidence. As to the fourth and fifth provisional measures requested by the Gambia, the question of their link with the rights for which the Gambia seeks protection does not arise. As to the sixth provisional measure requested by the Gambia, the Court does not consider that its indication is necessary in the circumstances of the case. The Court concludes, therefore, that a link exists between the rights claimed and some of the provisional measures being requested by the Gambia. The Court, pursuant to Article 41 of its statute, has the power to indicate provisional measures when irreparable prejudice could be caused to rights which are the subject of judicial proceedings, or when the alleged disregard of such rights may entail irreparable consequences. However, the power of the Court to indicate provisional measures will be exercised only if there is urgency, in the sense that there is a real and imminent risk that irreparable prejudice will be caused before the Court gives its final decision. The condition of urgency is met when the act is susceptible of causing irreparable prejudice can occur at any moment before the Court makes a final decision on the case. The Court must therefore consider whether such a risk exists at the current stage of the proceedings. The Court is not called upon, for the purposes of its decision on the request for the indication of provisional measures, to establish the existence of breaches of the Genocide Convention. It has to determine whether the circumstances require the indication of provisional measures for the protection of the rights under this instrument. It cannot, at the current stage, make definitive findings of fact, and the right of each party to submit arguments in respect of the merits remains unaffected by the Court's decision on the request for the indication of provisional measures. The Court recalls that, as underlined in the General Assembly Resolution 96-1, of entire human groups, as homicide is the denial of the right to live of individual human beings. Such denial of the right of existence shocks the conscience of mankind, results in great losses by the Genocide Convention, the Court considers that the rights in question in these proceedings, in particular the right of the Rohingya group in Myanmar and of its members to be protected from killings and other acts threatening their existence as a group, are of such a nature that prejudice to them is capable of causing irreparable harm. The Court notes that the reports of the fact-finding mission have indicated that since October 2016, the Rohingya in Myanmar have been subjected to acts which are capable of affecting their right of existence as a protected group under the Genocide Convention. As indicated in Resolution 74/246, adopted by the General Assembly on 27 December 2019, this has caused almost 744,000 Rohingya to flee their homes and take refuge in neighboring Bangladesh. According to the 2019 report of the fact-finding mission on Myanmar, approximately 600,000 Rohingya remained in Rakhine State as of September 2019. The Court is of the opinion that the Rohingya in Myanmar remain extremely vulnerable. In this respect, the Court notes that in its Resolution 74/246 of 27 December 2019, the General Assembly reiterated, and I quote, its grave concern that in spite of the fact that Rohingya Muslims lived in Myanmar for generations prior to the independence of Myanmar, they were made stateless by the enactment of the 1982 citizenship law and were eventually disenfranchised in 2015 from the electoral process. End of quotation. The Court further takes note of the detailed findings of the fact-finding mission on Myanmar submitted to the Human Rights Council in September 2019, which refer to the risk of violations of the Genocide Convention, and in which, I quote, it is concluded on reasonable grounds that the Rohingya people remain at serious risk of genocide under the terms of the Genocide Convention. End of quotation. The Court takes note of the statement of Myanmar during the oral proceedings that it is currently engaged in repatriation initiatives to facilitate the return of Rohingya refugees present in Bangladesh, and that it intends to promote ethnic reconciliation. peace and stability in Rakhine State and to make its military accountable for violations of international humanitarian and human rights law. However, in view of the court, these steps do not appear sufficient in themselves to remove the possibility that acts causing irreparable prejudice to the rights invoked by the Gambia for the protection of the Rohingya in Myanmar could occur. In particular, the court notes that Myanmar has not presented to the court concrete measures aimed specifically at recognizing and ensuring the right of the Rohingya to exist as a protected group under the Genocide Convention. Moreover, the court cannot ignore that the General Assembly has, as recently as on 27 December 2019, expressed its regret that, and I quote, "the situation has not improved in Rakhine State to create the conditions necessary for refugees and other forcibly displaced persons to return to their places of origin voluntarily, safely, and with dignity." End of quotation. The General Assembly reiterated at the same time its deep distress at reports that unarmed individuals in Rakhine State have been and continue to be subjected to the excessive use of force and violations of human rights and international humanitarian law by the military and security and armed forces, including extrajudicial, summary, or arbitrary killings, systematic rape and other forms of sexual and gender-based violence, arbitrary detention, enforced disappearance, and government seizure of Rohingya lands from which Rohingya Muslims were evicted and their homes destroyed. Finally, the court observes that irrespective of the situation that the Myanmar government is facing in Rakhine State, including the fact that there may be an ongoing internal conflict between armed groups and the Myanmar military, and that security measures are in place, Myanmar remains under the obligation incumbent upon it as a state party to the Genocide Convention. The court recalls that in accordance with the terms of Article 1 of the Convention, state parties expressly confirmed their willingness to consider genocide as a crime under international law which they must prevent and punish independently of the context of peace or of war in which it takes place. The context invoked by Myanmar does not stand in the way of the court's assessment of the existence of a real and imminent risk of irreparable prejudice to the rights protected under the Convention. In light of the aforementioned considerations, the court finds that there is a real and imminent risk of irreparable prejudice to the rights invoked by the Gambia as specified by the court. From all of the foregoing considerations, the court concludes that the conditions required by its statute for it to indicate provisional measures are met. It's therefore necessary, pending its final decision, for the court to indicate certain measures in order to protect the rights claimed by the Gambia as identified by the court. The court recalls that it has the power under its statute when a request for provisional measures has been made, to indicate measures that are in whole or in part other than those requested. Article 75, paragraph 2 of the Rules of Court specifically refers to this power of the Court. The Court has already exercised this power in the past. In the present case, having considered the terms of the provisional measures requested by the Gambia and the circumstances of the case, the Court finds that the measures to be indicated need not be identical to those requested. Bearing in mind Myanmar's duty to comply with its obligations under the Genocide Convention, the Court considers that with regard to the situation described earlier, Myanmar must, in accordance with its obligations under the Convention and in relation to the members of the Rohingya group in its territory, take all measures within its power to prevent the commission of all acts within the scope of Article 2 of the Genocide Convention. In particular, A, killing members of the group, B, causing serious bodily or mental harm to the members of the group, C, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part, and D, imposing measures intended to prevent births within the group. Myanmar must also, in relation to the members of the Rohingya group in its territory, ensure that its military, as well as any irregular armed units which may be directed or supported by it, and any organizations and persons which may be subject to its control, direction, or influence, do not commit acts of genocide, conspiracy to commit genocide, direct and public incitement to commit genocide, attempt to commit genocide, or complicity in genocide. The Court is also of the view that Myanmar must take effective measures to prevent the destruction and ensure the preservation of any evidence related to allegations of acts within the scope of Article 2 of the Genocide Convention. Regarding the provisional measure requested by the Gambia, that each party shall provide a report to the Court on all measures taken to give effect to its order, the Court recalls that it has the power reflected in Article 78 of the Rules of Court to request the parties to provide information on any matter connected with the implementation of any provisional measures it has indicated. In view of the specific provisional measures it has decided to indicate, the Court considers that Myanmar must submit a report to the Court on all measures taken to give effect to this order within 4 months, as from the date of this order, and thereafter every 6 months, until a final decision on the case is rendered by the Court. Every report so provided shall then be communicated to the Gambia, which shall be given the opportunity to submit to the Court its comments thereon. The Gambia has further requested the Court to indicate measures aimed at ensuring the non-aggravation of the dispute with Myanmar. In this respect, the Court recalls that when it is indicating provisional measures for the purpose of preserving specific rights, it also possesses the power to indicate additional provisional measures with a view to preventing the aggravation or extension of the dispute whenever it considers that the circumstances so require. However, in the circumstances of the present case, and in view of the specific provisional measures it has decided to indicate, the Court does not deem it necessary to indicate an additional measure relating to the non-aggravation of the dispute between the parties. The Court reaffirms that its orders on provisional measures under Article 41 of the statute have binding effect and thus create international legal obligations for any party to whom the provisional measures are addressed. The Court further reaffirms that the decision given in the present proceedings in no way prejudges the question of the jurisdiction of the Court to deal with the merits of the case or any questions relating to the admissibility of the application or to the merits themselves. It leaves the right of the governments of the Gambia and Myanmar to submit arguments and evidence in respect of those questions. For these reasons, the Court indicates the following provisional measures. 1. Unanimously, the Republic of the Union of Myanmar shall, in accordance with its obligations under the Convention on the Prevention and Punishment of the Crime of Genocide, in relation to the members of the Rohingya group in its territory, take all measures within its power to prevent the commission of all acts within the scope of Article 2 of the Convention, in particular, killing members of the group, causing serious bodily or mental harm to the members of the group, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part, and imposing measures intended to prevent births within the group. 2. Unanimously, the Republic of the Union of Myanmar shall, in relation to the members of the Rohingya group in its territory, ensure that its military, as well as any irregular armed unities which may be directed or supported by it, and any organizations and persons which may be subject to its control, direction, or do not commit any acts described in point 1 above, or acts of conspiracy to commit genocide, of direct and public incitement to commit genocide, of attempt to commit genocide, or of complicity in genocide. 3. Unanimously, the Republic of the Union of Myanmar shall take effective measures to prevent the destruction and ensure the preservation of evidence related to allegations of acts within the scope of Article 2 of the Convention on the Prevention and Punishment of the Crime of Genocide. 4. Unanimously, the Republic of the Union of Myanmar shall support to the Court on all measures taken to give effect to this order within 4 months, as from the date of this order, and thereafter every 6 months, until a final decision on the case is rendered by the Court. I shall now call on the Registrar to read the operative part of the order in French. You have the floor.
Merci, Monsieur le Président. Par la Cour indique à titre provisoire les mesures conservatoires tous les 6 mois jusqu'à ce que la Cour ait rendu sa décision définitive en l'affaire. Merci, Monsieur le Président.
Judge Cansado Trinidad appends a separate opinion to the order of the court. Judge Ad hoc Kress appends a declaration to the order of the court. The text of the order is available from today in TypeScript. It will be available shortly on the court's website. The printed text will be available in due course. As the court has no further business before it today, I declare the sitting closed.